on the 3 criminal laws that are now being pushed through Parliament. We've heard a perspective from the government on why they feel this is game-changing on the repealment and replacement of British-era laws. Let's hear a perspective from one of the most eminent jurists in the country, a person who was supposed to lead the opposition conversation on this matter, a 3-time member of Parliament, and somebody who is going to help us now work this out, because not only has he been current chairperson of the Parliamentary Standing Committee on Commerce, he's been the former chairperson of the Parliamentary Standing Committee on Law and Home, including members of the Standing Committee. He's a senior CWC member, he's been a former ASG, and currently is the senior most national spokesperson of the Congress Party. Dr. Abhishek Manu Singhvi joining us on the broadcast. Dr. Singhvi, I believe, of course, you wanted to make the presentation in Parliament. You haven't had that opportunity thus far. What is your in premise? We'll get into the details immediately, but in premise, do you think this is a good idea?
Thank you for a generous introduction, Rishabh. I am personally obviously feeling bad that having looked into it some length, I'm not able to open the debate, but these things happen. In a nutshell, I am critical of this set of bills. A, because they are the most cosmetic of cosmetic changes, even though touted and claimed to be the most structural or important. B, they are doing this for the wrong reasons. Must change a law. I am all for changes. I have several suggestions for incorporation, but not because the law is created by Rishabh Gulati or by Abhishek Singhvi or by Britain or by non-Britain. The intrinsic law must be bad enough to want to change it. Third, because what they could have done, they have had a historic missed opportunity. Because your interest is really only renaming Namkaran. And if your interest is to leave your identity and your mohar, then the whole exercise is flawed. Therefore, you actually missed out the 3 or 4 major changes you could and should have done, which you have not done. And the fourth aspect is that what you have done is really retrograde in many, many respects. I can give you a few examples presently. Very retrograde, wrong, should not have been done, and so on and so forth. So on all fronts, I am very critical and very sad that these bills are being passed. And that too, of course, above all, without any input, without any discussion, on a very ridiculous set of egos that we will not speak about this Parliament security breach in Parliament. And if you protest about your not speaking, then we will suspend you en masse to 143 persons.
Okay, let's jump into the details. So now you mentioned some things that you feel are retrograde. Let me talk about the highlights that are being discussed in the public, starting with terrorism, sir. Now, a definition of terrorism is being provided. I'm going to ask you on sedition and other matters subsequently after this. But what is your feeling? Didn't a definition of terrorism require to be amended?
It's a good example. It's one of my many examples of retrograde. I was going to start with sedition. Let's start with terrorism. In terrorism or anti-terrorism, you have already, as everybody knows, a special law. It's called the UAPA. We also know the basic principle of law, which is already there in the existing CRPC, which is now going to be called BNSS, which says that a special law will always prevail over a general law. Now, why I find no method in this madness, where the anti-terrorist law is, that in the proposed amendments, you have created a separate subset of anti-terror laws, a kind of another mini UAPA. The core harsher features of the UAPA have been eliminated here. So you have no reversal of burden of proof, not more stringent bail conditions, and admissibility of statements is not there. While you have made it less harsher, you have left it to the whim and caprice of a SP to decide whether I will prosecute Rishabh Gulati under UAPA or under the BNS. And you have given that SP no criteria to decide when why I will prosecute Rishabh Gulati under UAPA and Abhishek Singhvi under BNS. So it is completely arbitrary, and you will be selective, you will be playing games and favorites. And what is the need of this? If you had something like this, you could have made a few amendments to UAPA itself. You have a parallel regime, and you're going to have utter confusion in interpretation. You're going to have 2 regimes applying. You're going to have challenges by accused saying that this choice by the SP to apply the UAPA to X and a BNS to Y is all wrong.
Okay. Let's pick on sedition then, because I know the terminology has changed from Rajdroh to Deshdroh. There is an expanded definition about the unity and integrity of India. What is your criticism here? Because the government says that this required some change, required some updation.
I'm sorry to use strong words, but that example is nothing less than a fraud and a farce. But before I go there, just 1 minute more, that's similar to anti-terrorism. They've again created two parallel regimes for anti-organized crime. I'll give you just 1 minute because it's linked to the anti-terrorist law. There are Kakoka in Karnataka, Makoka in Maharashtra, and similarly in Punjab, Rajasthan, anti-organized crimes local state statutes, which have similar draconian provisions like the anti-terror law. This law now proposes a central anti-terror, anti-organized crime law in the BNS. Now, this time they don't tell you whether a person who wants to prosecute you in Maharashtra will use the Makoka or he'll use this BNS provision or maybe both, and they give you no SP test to differentiate. There is no method again here. Why have a All India new act when a lot of states have it? And if you have an All India state new act, then you have to decide when it will apply, how will it apply. So you're going to have lots of beautiful pro-lawyer, anti-litigant, anti-India litigation on jurisdictional turf wars. Coming to your question of sedition, Rishabh, I think is nothing short of, I said not entirely in jest, the government can't be called guilty of sedition. It is certainly guilty of betrayal. Why betrayal? On 11th of May 2022, you got a stay in the Supreme Court against sedition. In October of that year, 2022, you reiterated and the court recorded the assurance of the Attorney General that we are seriously considering redoing or revamping the sedition law. The stay continued, and suddenly on 24th of May 23 this year, 5 months ago, you had the Law Commission proposing the present avatar of sedition. The government in the next day's newspapers completely distanced itself, acting as if the Law Commission, we didn't know about this. And now they come with the same provision, making a difference without a distinction on issues like Rajdroh and Deshdroh. The old provision, Rishabh, to your astonishment, was life plus 3 years. The current provision is life plus 7 years. There is really no substantive difference between the language and the crux of the offense of the sedition earlier and this offense. Minor changes. Most important, Rishabh, we know the ground reality. You know that you are a journalist in Uttar Pradesh and somebody can pick you up for sedition, as has happened in several UP cases. You know that you say something to the disliking of the government in state X and Assam police comes and arrests you. There are actually real cases, many of which I have appeared in. And then somebody will turn around and lecture to you, oh, if you have a good case, why are you worried? The law will let you off. There is a protection of courts. They don't tell you that the process is the punishment. Of course you'll be let off, but you would have suffered incarceration for months. So this is betrayal. It is contrary to the expectation of the Supreme Court. It's contrary to your assurance. And you are now making pedantic difference without a distinction points about the law now and the law earlier.
Okay. What about matters like decriminalization of homosexuality, which has already been settled by the courts? Isn't it useful that the statutes now reflect that amendment?
Absolutely. In that sense, there are many minor changes which are very good. How can you object to a fact already struck down? You have actually taken it away. Very good. Of course, already state sedition you have reincarnated. But there's another very good thing for which I must compliment the government. They have brought in community service punishment instead of incarceration. Very, very good. My only small point there is that they must increase the list of offences where community service can be awarded. Small list now. Of course, they must make a caveat that second, third or fourth offenders, repeat offenders cannot get that. Otherwise, it's a good thing. Okay. But again, you missed a historic opportunity in the same breath of two things. You could have made this more reformatory and less punitive, this act. Increase the list of community service, but increase also the list of compoundable offences. There's a huge list out there where offences are not compoundable, where they are relatively minor and ought to be compoundable. Why do you want to be punitive? You have no place in jails. You have not done punishment alignment. There are several examples where a more serious offence has a lesser punishment and vice versa.
Okay. All right, but Dr. Singhvi, along with this, an effort has been on through government, and you are aware of this, that conversion of criminal provisions where you can be incarcerated, be sent to jail, into just civic fines. Now, the argument is being made that this will A, reduce the burden on the judiciary, B, make these matters less draconian, where you can issue a fine, why threaten someone with prison, and the same argument which you made that the local police then get to decide whether they want to send you a jail or impose a fine, that power from them goes away. Aren't these healthy, good things to happen?
Absolutely. I welcome them. If you look carefully, you'll find the degree and the numbers very small. You should have expanded them. I am clear that I welcome them. But just note the subtext, the devil and God lie in the details. You talked just now about lesser cases or faster moving cases. You know, the path to hell is sometimes paved with good intentions. I'm not saying this can be the intention of any government to increase our 5 crores mind-boggling areas. But the result of your actions, howsoever unintended, can be that. You have made cosmetic changes, Rishabh, and cosmetic is an understatement of the century. You have actually substantively made changes in the IPC BNS to only 2.24%, in the Criminal Procedure Code BNSS to 1.68%, and to the Evidence Act Sanhita BS only to 0.17%. But those small changes will technically allow an accused to argue that 150 years of layered jurisprudence on the old section by Supreme Court and High Courts, because it suits the accused to so argue, should be ignored now because the law is new. New by a cosmetic change, transferring sections from this section to that section, consolidating them. And the judge will ultimately reiterate the old law, but he may take months to de novo hear the arguments on a section which is technically new. Do you know, I'm a litigator, so I understand the dynamics of this and the dialectics of this. Do you know the additional time wastage, and these 5 crore arrears can go to 6 crores? Is that the possibly intended consequence? I'm not accusing the government. No government will have that. But when you do things from the overall object, that you must leave your imprint, it's an identity issue. It's an ideology issue, not an issue of substance. Then you make these blunders.
Okay.
What is the point, for example, of making hundreds of changes in the IPC, which are only transferring from this section to that section and consolidating them?
Okay. What about the substantive issues like lynching, hit and run? How do you observe these?
Lynching, the provision is at least now focused on one activity, so I welcome it. But I would much rather have had this was an opportunity when you're bringing in three new Sanhitas. It was an opportunity which you've lost. Most important, fundamental police reforms. Why could you not segregate and separate investigation from prosecution? It is only in India, with the size of India, that a poor police officer gets up in the morning, goes to the field, does a couple of hours of collection of evidence to which he gets attached naturally because he has collected it, comes back and bangs his head in court for 2 or 3 hours, goes to office and sits with the superior to decide whether the evidence collected by him is prosecutable or not. And then, of course, does petty service sometimes for his superiors. The poor man is overworked, impartiality and objectivity suffers, attachment to your own evidence increases. No Indian wall, not Chinese walls, are built between your investigative roles and your prosecution roles. This has been recommended by the Supreme Court 3-4 decades ago by any number of law commission reports. Why could you not do it? You have, of course, the extreme example, which I am not saying it should be so ferocious here, of the district attorney in USA, who is a completely independent prosecutor who rejects evidence which he doesn't think is good enough. There is a lesser and a better model to copy, the Director of Public Prosecutions in UK. You don't have it. Okay. This is the reform you should have done. This was the opportunity you've lost.
Okay. Okay. What about other things like simplification of the definition of bail? You are now being told there's a concept of plea bargaining for first-time offenders. You're being told that bail and acquittal cases will be simplified. We are being told that electronic FIRs will make the process simpler. Do all of these, I know the proof of the pudding is in the eating, sir, but do all of these in logic at least make sense?
Yes, many of them do. I won't say all, many of them do. Why not have electronic FIRs? You've got everything done by electronics now. Digital courts are there. But equally, just don't take what they're doing. They're telling you a lot of the more peripheral and the minor ones, on which I have no objection. But there are these pernicious ones. There are the missed opportunities. And I think that you are doing it not because of the intrinsic worth of the law. You should have gone to clause by clause analysis, saying these are good, these are bad, and these are slight modification, and then done it. Not because the author of one is Rishabh Gulati, so I must change it. The author of the other is Singhvi, who has not changed it. That approach is what is coloring this.
Okay. Dr. Singhvi, now, so what's the next step ahead? I know this is not a complete exercise. There will be opportunities to take this forward. In principle, are we headed, at least in the logic, that a lot of these things need to be relooked at? Because you say, if it's not broken, don't fix it. Things that are broken, fix it. What remains broken that requires fixing?
And I believe also there are a lot of things which are in fact broken are not being fixed. Of course, which is not broken should not be fixed just because you want to change the identity of the person who originally made it. That's the second category. But now going forward, there's nothing much because these are now here to stay. It's a separate story that they've been passed without any of these inputs, without any of these discussions. It's tragedy that the country will be having 3 sets of criminal law with the entire opposition missing. But that apart, today now we have to do with what we have. I only hope and trust that judges don't start pulling out their hair in trying and re-deciphering and leading to delays. And I just pray to God that 5 crore doesn't increase because of this to 6 or 7 crores.
Do you expect challenges in the courts regarding these laws as well?
Oh, absolutely. Many, for example, the anti-terrorist law, the lack of choice, the lack of criteria to decide whether you proceed against one or the other would be liable to be challenged. Many more.
Okay.
But it's not a question of only the constitutional challenge. It is also a question of the interpretation and the application of these laws. You just set a cat amongst the pigeons by increasing the workload of courts immeasurably.
Okay, all right. You heard it there, the perspective from Dr. Abhishek Manu Singhvi, who was supposed, of course, to lead the debate in Parliament on this, and for various political reasons that hasn't happened. Nonetheless, for explaining your views as eloquently and as a detailed clause-by-clause manner as possible, Dr. Singhvi, appreciate your time. Thank you for joining us.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.